This meeting is being recorded.
Good morning, friends. I welcome you all to this lovely Saturday morning for our webinar on the recent order number 29 of 2022 of Maharera, which is now a hot topic amongst all the developers, more particularly, and amongst those who could not file a complaint against a person under section 31, right? So I welcome you all, and to brief about the association from this month onwards, now we will be having uh, many webinars, maybe at least once in a month or maybe more than that. And we require a large membership base, and we request all of you to please share the association activities amongst your network so that many people can join the association. They get the benefit. There is an exchange of views and ideas. There is a networking possibility and all that. Like Sanjay Bhai and I, we were not known prior to Rera, but now we have a very good networking, exchange of ideas, and so on. So whenever we meet on a common platform, we also grow, and other also grow, and our knowledge also grow. So these are the our intention of the association. So I'll request all the member to add more member to this association so that we have a very good strength, and we can represent. We can even file some SLP before High Court or Supreme Court wherever we feel that there is injustice or some improvement is required. Now, I will not indulge into the subject of the speaker, but this particular order is addressing the issue of the complaint which we cannot file against any other person. Now, under section 31, only 3 persons we can target, that is promoter, allottee, and real estate agent. Any aggrieved person can file complaint, but against whom? So against only these 3 persons. That is what section 31 says. So this order will enable a aggrieved person to go ahead, but only so far as the regulatory framework is concerned. I think speaker will indulge into in detail about that. With this brief introduction, I will now request our treasurer, Sri Aditya Jante, to introduce our today's speaker, who is also our committee member, Dr. Sanjay Chaturvedi. Over to Aditya.
Thank you, Ashwin sir. It is indeed a pleasure to have a excellent and experienced speaker like Sanjay Chaturvedi sir. To begin his introduction, Sanjay Chaturvedi sir is a chartered accountant. He is an advocate and a PhD holder. He is a Rera expert and advocate in real estate law and taxation and international arbitration. He has authored 67 books. He is chairman, board of studies, Niranjan Hiranandani School of Real Estate, director, real estate studies, All India Institute of Local Self-Government, and instrumental in many research for government of Maharashtra, Goldman Sachs, Chrysler, KPMG, EDCO, ICICI Securities, and others. He is having a wide academic experience of visiting faculties at various colleges and institutes such as NMIMS, Department of Commerce, University of Mumbai. He is also having an expertise in as a role of editors in various journals and even various reports for such as Accommodation Times Media and Communications Private Limited, Accommodation Times, then Journal of Real Estate Management. And he has authored various books such as Real Estate Finance, Rera versus NCLT, Pranayam, Car Parking Rules in Maharashtra. These are just a few names. As we all know, he has authored 67 books. He has also submitted various papers such as Recession or Recess, National Commerce and Management Conference of Financial Risk, then NICMARC Journal on Real Estate Price Trend on November 2010. Then he has also been instrumental in teaching right from the beginning of his career. So with wide range of experience, and today we are very much I mean to say, happy for having you as our speaker to enlighten on this important order released by Maharera. So we welcome you, sir.
Thank you, Aditya, for a very nice introduction. I could now come to know one more quality of Sanjay Bhai, that is, he has written book on pranayam. So we'll certainly keep some session on that also. That is very much required now to all our professionals. So with this, now I'll request Sanjay Bhai to continue. Yeah.
Thank you, Aditya and President Sir. This is a wonderful Saturday morning, and I believe that people in this forum, all learned people, and we are practicing Rera and various allied subjects, including real estate law at various forums in Mumbai and other places. I believe that we all know that, and that is a common knowledge, that after 5 years of Rera, we have fought hundreds and thousands of cases in various courts in Rera, then tribunal and high courts. But we were confined to only Section 31. We all know that Section 31, where only aggrieved people can go, and very rightly said by President Sir that these only 3 people were to file a complaint on and in Rera. And but of course that there may be some other forums also, like consumer forums, MOFA and other places. People are more comfortable there now, NCLT also. But now, since it has all emerged that when very recently Honorable Bombay High Court came up in a writ petition 8717 in Vayuputra versus Maharera and some other people, including DB Realties. The writ petition was basically, what? It was that the promoter wanted to actually deregister one of his project, and there was no provision as such in the Rera. Now, since there is no provision in Rera for deregistering the project and for taking this, it was all depend on the suo moto action of the regulatory framework or the regulator's prerogatives, where only regulator can either suo moto take this cognition, or there was no actually framework or maybe no process or procedure for a developer or a promoter to either rectify, amend, or deregistered altogether. Now, this is what had come up with the return, in the rate, and the Bombay High Court, Honorable Bombay High Court, has actually came up with a suggestion to the Maharera, saying that why don't you not just replace the suo moto, or alternatively have some arrangement for suo moto where some regulatory framework can be have adversarial litigations and people get chance to prove their bona fides. So let me just start this introduction. Let me start with the presentation, which I'm having some PPTs prepared for you. And what we'll do is that the first half, maybe 15-20 minutes, I'll just explain what exactly the Bombay High Court, and then how Rera came up with the directions given by the Honorable Court. And then next 10-15 minutes, we'll have some open forum. We can have some question answers, and the other, my learned friends also can participate in the discussion. So let me share the screen for you. And the host has disabled attendee screen sharing. So please, my request is to please enable my screen sharing. Aditya?
So I think so.
संजय जी थोड़ा माइक से नजदीक आ जाइए ना संजय जी
मैं
क्लियर
अच्छा
क्लियर नहीं आ रहा है
वो एक सेकंड
Ashwin sir, you can allow him to share the screen.
Please allow me to share the screen, please. Yes, 1 minute. So the today's subject is the SOP, the standard operating practice for filing cases arising from regulatory functions of Maharera. The basic order which was I was referring to of the Honorable Court was that it has all came from the writ petition 8713-17 of 2022 of Bombay High Court, which said that the Rera should come up with some regulatory framework or some leverages where the parties can come with an adversarial litigations and prove their bona fides, and not just depending on the suo moto prerogatives of the regulator. Now, what is the process? Let me first very quickly glance what the procedure the Rera came up with. Then that was actually Maharera order came up with of 29 of 22, dated 25th April 22, and then immediately the Rera has actually come with the procedure along with some forms and form for the affidavit also, and this is where the process lies. It will change a lot of things, I tell you, because the people, those who were actually looping in dark as far as the section 31 was concerned, and I'll give you n number of examples. It's not just a deregistration, but all the regulatory sections like 3, section 4 and other sections, where we will give you examples that what exactly now can come under this order 29. Now the order 29, the process was to alter the practice of giving the nomenclature suo moto. That is, the suo moto is basically only the prerogatives of the regulator. As you and I know that the Rera is having two different, you can say, power. One is a caution judicial office, authority and the powers. One is the regulatory powers. Now, in the regulatory powers, basically, only Rera could actually come up with a suo moto notice and have a regulatory matters adversarial in nature, and accordingly the following directions were given under the order 29. The process was that they have said in the order itself that the regulatory matters that take the forms of adversarial litigation shall be filed in a manner that is, they had given one Annexure A, which we are going to discuss what exactly Annexure A, and it is there on the Maharera's website. You can go and check that Annexure A also. Now, the second order which has come with, that is within the order, the part that the statement of fact contained in that while filing the complaint shall be supported by some affidavit. That is, the affidavit also the format is being given by the Rera, and it is nothing new. We know that these are the usual affidavits. The letter notifying defects, that means if this is the CPC process, suppose you file and complaint, the authority or the court usually come with some objections where you need to clear the objections while filing. This is right now offline, but then the Rera will come in a later stage with an online complaint like this. Let's see. And the other part is that until a digital module, that is what it says, that if it is available, then till that time it will be offline only. And the direction shall not apply to complaint filed under section 31 of the Act. That means you and I know section 31 is basically for the people, those who have aggrieved under the person is also defined under section 2 subsection P, which also says and identified that these are the certain persons which are those who are eligible and those who are aggrieved can file for any violation of the Act. But now section 31 have actually got limited to only, as rightly President said, to file against the developer, against the agent. And some of the developer also have filed under section 19 that for the relief under section 19 against the buyers also. Now, The regulatory matters which are not adversarial in nature, the practice of using the nomenclature suo moto shall continue. That means the suo moto authorities' prerogatives will continue. But there was some bifurcation required where why only the power of the authority for suo moto? Why cannot I go with the subject matter, just like DB have actually gone into High Court, said that if you want to deregister the project or alter the project, then why I should not get chance? Neither I am eligible in Section 31, nor the authority is inviting me suo moto. So there has to be some way out for those adversarial litigations where a litigant needs to prove or needs to tell the authority that, okay, sir, this is what the regulatory prerogatives need to be either change or modify as far as I'm concerned. Let the procedure be like this. In the order 29, very quickly, of course, it is anybody can read this, but need some clarifications on this. That is why I have just reproduced those text over here. That there are no formats or prescribed form for filing the regulatory matters, adversarial in nature, and we are going to discuss what is adversarial litigations. That there is no format for this, and right now the nature as the same are of varied type, and they are rightly said. I will just describe those few which needs to be actually identified immediately. Maharera shall especially notify designated email IDs for filing of regulatory matters, that they are going to give us a email where we can actually go and file these matters duly displayed on notified website. Considering the different type of stakeholders, the registry will not prevent hard copies of filing by person who may not have access to the e-filing facility. So both e-filing and the hard copies are also available. The statement of fact contained in any filing shall be supported by a duly notarized affidavit. That is very important for them. Now they want that the Evidence Act or the on affidavit, all what the papers are to be submitted has to be notified and affirmed under the oath. Now every affidavit shall be drawn up in the first person and shall state the full name. Of course, that is the usual practice of the affidavit. I am not going in detail. If on scrutiny there is some objections or some application, plea or representation is found to be defective, the defect shall be notified to the parties. Sorry, I think this is a wrong slide which has come in. A person agreed by any order of the secretary in regard to the presentation of a submission, application, plea, representation may request the matter to be placed before the chairman of the Maharera for appropriate orders. That means, for suppose there some defects are there and still you are not accepting that these are defects basically, then you can escalate it and go to the chairman and say that, sir, this is not the defect, but it needs to be input in my complaint itself. That is the hierarchy which actually the Rera has come up with. And yesterday when I was with the chief legal officer also, then I was actually having the clarification on this. He said, see, we have to have some mechanism given that the authority, if suppose there is some authority which is not convinced, you can always escalate it before, and you don't need to go to the tribunal or to go to this. We have our own mechanism over here in the regulatory procedure, so that we rectify. And suppose if you are not satisfied, you can always escalate, and we can solve it all together over here. So multiple litigations going in on a higher courts, then it is not needed. If it is regulatory, then it has to come to us only. So if it is just paperwork, we can just solve it over here. And if on the scrutiny, the petition is accepted, or in case any order or refusal is rectified by the chairperson or the member of the Maharera designated, see, even chairman can or the authority can designate any officer for this regard. the petition shall be duly registered and given a number, and then the number to be determined by the Maharera itself. So just like a complaint filing in a court, we have that mechanism in place. The registry at Maharera shall issue notice to all the concerned stakeholders, and that is all that we also require that all the parties to be give. Suppose what it happens is this, where a developer saying that okay, I want to deregister, and I have paid every person who has actually booked, and there is no now claim of any buyer or any allottee or whatsoever, or any vendor or any issue as far as the landlord is concerned, then it is a one-sided affidavit and one-sided, you can say, adversarial litigations. But then Rera wants to understand that whosoever is an interested party, though, so the onus is not on the person who is filing the complaint, but on affidavit. Suppose if you are going to put that these are the parties, and you will see that the form of the affidavit and the form Annexure A, which is mentioning, you need to have a material disclosure on that who are these people, those who are actually interested in these procedure. So that is why the Maharera has not put an onus on us. It is that the Maharera itself is going to invite all these parties. Then there would be no list board, and there will be no any you can say prepared for these matter board or cause list or whatever. It will be absolutely regulatory procedural decisions. That's why it is not going to be in the cause list. Prior notice of the scheduled date of the proceeding will be given, and pleading as per the CPC. So this is what it is. So I'm directly now jumping to the various issues that had come up, and in recent past, where the Rera was only confined to suo moto regulatory procedural, now we are having a bifurcation into suo moto and the adversarial litigations. Let's understand the adversarial litigation first before we jump to the examples under these sections. And but of course we have to just check under the writ, where it has all derived and originated, what was the matter, and then why we are subject to this order 29. See, the adversarial litigation is basically where onus is on the litigant to prove their bona fides or the cause of content, there where he says that okay, I should not be subject to some such regulatory procedures. And if suppose, just for example, in the writ itself, where the promoter wanted to deregister a project, there was no procedure as such in deregistration. I'll give some more example in this. Suppose a developer wrongly put an address of the site according to the office address. Suppose the developer is in Mumbai and the site address is in Pune. Now, while filling the registration form, it is very much confusing while putting a address of a project site. Sometimes the promoter usually put the office address in the site address. But since the zonal classification of the Maharera and the software not allowing you to jump between the division. Suppose it is Konkan division and then it is Pune division or maybe some other division. So if I go and rectify such type of mistakes, I have to tell the Rera, said, see, this is the project which is now not in Mumbai actually. I wrongly put the project site address as Mumbai because I thought that you want me to put the office address over here. Now, if I want to just discontinue one of the phase in my project, for example, that there was a project in Konkan region where the project was in one of the portion of the land where the railway has acquired the land. And because the railway has acquired the land, the entire orientation of the project has changed. One of the building where the land was acquired by the railways, now that building is impossible to construct. So the developer, using the FSI was granted within the plot, he wanted to relocate the project, the building over here. And then once it is relocated and then other things, then he says that since my 1.5 year has gone into the notice and all those procedures and this, I want to enhance my date of completion, because now from scratch I have to, my all piling work and other thing, building has been demolished or whatever, maybe the plinth or whatever. Now I want to construct at some other site within the plot. So I need to enhance my project completion date over there. Now, such type of regulatory things which is not going to be coming under Section 31. Neither the authority has suo moto given me any notice where why you should, maybe whatever reason, suppose one of the project in Andheri, there are 4 wings. Now wing A, B, C, D. The developer has constructed wing A, wing B, wing C also. Now instead of the, can you mute your mic please? Okay, thank you. So if instead of wing D, now he wants to actually construct, go higher floors on wing A, B, and C instead of D, because he wants some open area in the project, and instead of constructing D, he wants to go higher up. So any change under Section 14 or any change in the layout where he is supposed to, and he has not sold anything, and suppose even if he sold anything in D, say maybe 1 or 2 flats are being sold, then he is asking the buyer to please come forward, take your money, because it is impossibility of the contract, and I cannot now construct the D because of whatever reason, and now I want to enhance my FSI, or maybe go vertical instead of horizontal. Now this is the change, the prerogative of the developer while construction is there. Such type of examples needed are not going to fit in Section 31, nor the suo moto, because the authority is busy, or maybe they may not going to be taking suo moto's cognition of such type of thing, because unless you tell the authority is not going to listen. If it is going to be listening, sir, somebody's mic is on. I will request Nitya ji to mute them.
Yeah. 1 minute.
Thank you. So, thank you, sir. So, basically, the question over in the Honorable Bombay High Court in the writ, that the deregistration process of a project which is not falling under Section 31 and needed some attention of the authority, where the authority is not going to take a cognition suo moto.
Hello, who is there?
Thank you, sir. So that is where the suo moto action needs to be taken by the host now. So I'll just keep the host on the. So this is where I actually got stuck. The Honorable Court has actually wanted Rera to come with a framework to understand and bifurcate the power between suo moto and the adversarial litigation. Now, what is adversarial litigation? The adversarial litigation is basically when I go and approach the court, and then I decide on the bona fide, saying that, sir, this would have been actually given.
Who is there?
Dilip sir, please mute yourself.
Dilip Agrawal is there.
I am muting him, but again and again it is automatically getting unmuted.
Why don't you please ask him to just log out and log in again? Maybe some software problem with him. So it's like that way. Okay,
Okay.
now continuing with our subject, because we're having a limited time to complete all the sections. Dilip
I,
sir, can you please mute yourself or
I
just
will,
log out and come back again?
So
I
I've
will,
So,
done it. I've done it. I've put him in waiting room. You can continue.
okay. Ji, thank you. So, when the adversarial litigations are where the onus in the litigant to tell the regulatory authority saying that you need to give me an order and I will prove my bona fides. Now, this is what the adversarial litigations taking bifurcation between the power of suo moto, which the authority would have actually taken a suo moto. And unless I tell the authority what had happened to me, the authority is not going to actually take, and that mechanism is not there to tell the authority. The mechanism was only that you need to go under section 31, fill the form, A or B for whatever reason, and then that's it. Now coming under section 3 and 4, very quickly I'll give you some examples so that it will be very clear between us that what are those adversarial litigations which can or are have arisen in the recent past or maybe in last 5 years, that and you will recollect immediately that yes, this was a right case for the order 29. Suppose there is a conflict between the landlord and the buyer, and the promoter, and the landlord says in 2014 I have actually terminated your DA. Now how can you go and register a project which is under the termination of the DA? And where do I go under section 31? No, because I'm also a deemed promoter, and I need to actually either tell the regulatory authority, which I did also in the past, that says please don't register, or even if suppose you registered, then you please make me also a co-promoter, and all those powers of the promoter should also vest under on me, so that I am also either liable or maybe having a bona fide beneficiary of the project. So unless I give him the power. Very recently also, now the societies, and and then we know that what is going on and the conflict between society developer and elsewhere developer. Now such type of situation also come under order 29, because there is a conflict of promotership between the promoters, and the buyer do not have anything to actually talk about. And of course, when the society is not actually recognizing either the developer, elsewhere developer, or maybe going to have some other developer also. Very recently we have come up with, and there are some rulings of the honorable tribunal also under section 3, that why and who should actually register this project. I say that I don't want to register, I do not come, and the interpretations the developers themselves make them, saying that okay, I am not coming under Rera. And who will tell the Rera if suppose there is some agreed person who says that okay, you need to register? So all unregistered project where a registration is not there, and can I tell and if I'm an aggrieved person also, that the regulatory authority must act under section 5, that some project need to be registered, instead of they're not registered and people are having their own interpretations. The biggest, you can say, question is under section 7 and subsection 3 also, and subsection 8 and 8 also, where a regulatory power for determining the unfair trade practices. I'm just not confining myself to the extension basically of under section 3, where the Rera has come up with the procedure saying that you require some certain percentage for giving you a permit to enhance your date in the completion date in Rera. But when it is not just confined, section 7 is not just 7.3, it is basically some other portions and the you can say provisos of section 7, where a regulator needs to actually would have actually gone in with a suo moto, but some suo moto actions are not being taken by the Rera, and very rightly so, which if I give you some example, that then when you are advertising without taking a registration, and many projects were fined. You have seen, in the beginning of Rera, that many people have put a fine of 10 lakh, 12 lakh, and maximum fine of 50 lakh rupees also was paid by the developer for not either including the website name or address on their advertisements, or advertising without the registration. Now, such type of thing which act also can be bought under the order 29 of Rera, where a Rera authority now having a mechanism where a person come and seek some relief under section 7 and 8. The popular being section 14, where I have given you some example that the orientation and some major you can say reshuffle in the plan area, or maybe discarding the project, or deregistration of project, or deregistration a part of the project. Some of the developer to whom I know, and some I was catering them, that a project was having a large layout. Now, because of whatever reason, sometimes it is height restriction, sometimes environmental permission, sometimes reservation is imposed on them. Sometimes there is a now very recently you have understood, you came to know there is a unified DCR in entire Maharashtra for the except for the city of Mumbai. Previously, it was actually all three zones and zonal classifications for Maharashtra under Land Revenue Code. Now, since we are having a unified DCR in entire Maharashtra, that means every square inch in Maharashtra is subject to now that it is a planned area where it is subject to the regulatory authorities prerogative. Wherever you want to construct or develop any project in Rera, in real estate, you need to actually take a registration, and you cannot say it was a gram panchayat, or you cannot say it is a a development of a bungalow plot or whatever. If it is fitting more than 8 units, or if it is either way 500 square meters, then you need to take a registration. Then section 15. Now section 15 is very tricky as far as I tell you, because some of the cases like the circular of Maharera which has come up in section 15, you must have understood that there was 3 scenarios given under section 15, and one of the scenario was that it can the promotership can be changed either by the SURFACE Act, where a lender can come up with saying that, okay, I have thrown this the developer out and I am taking the other developer in. And I can give you a number of example on this, that section 15, when as a financer, I need that the Rera should take an action, and I tell the Rera, okay, now this person is ceased to become a promoter under SURFACE Act, and now I have introduced some other person. Now, under section 15, there was absolutely a discretionary power given to the buyers, unless I give up as a buyer the consent to change the developer. It is not possible for anybody to change a promoter. Now, to changing a promoter, suppose promoter has sold the project, you forget about SURFACE Act. If the promoter wants to sell the company by itself, only the directors are changed and the company is same. This is the second scenario. And if the company is being changed, or some other company is coming in, then such type of, if I want to take an order under section 15 for change of promotership, or maybe introducing some co-promoters, suppose I'm taking some financiers, or maybe some merger and acquisitions happens in real estate, then I want to take on board some other developer also, or maybe some project manager in the project, where now he will act as a promoter. Then what do? I have to introduce him as a promoter, and under what circumstances and what documentation I have to tell the Rera, because Rera has not given me any order. Neither there is any other appropriate authority has given me that order to replace or have a merger as a promotership under section 15. Then in that case, I will approach Rera under order 29. I said, sir, now I will share the platform with us, my co-promoter, and either way, whatever, MOU or whatever, there are some provision in the software itself. You can just go tick say that okay, now I am having a area sharing or profit sharing. But what if I am not neither sharing area nor sharing profit? I am for some fees. I am coming as a project manager, and I want to behave like a promoter because I am funding the project and I want to complete it. And then whatever the revenue comes in, I will take it in the sale proceedings. So I'm not actually sharing the revenue. Basically, I'm taking a fees, and that is happening in Rera. So to cope up with such type of scenarios where under section 15 there are various takes, and just because of the limitation of time I'm not explaining the various type of situation under section 15 needs to be actually adhered to. And when the Rera, unless I tell the Rera that this is what exactly had happened, the Rera is not going to have a suo moto unless it has have its own mechanism. And of course the section 17 where there are various provisions, we know that then the Rera has actually of course have rules. We have the sections, we are having some certain provisions. Now we are fighting where the association of LOTs now seeking some now relief from Rera, uh, constituting the either society or condominium or whatever. And then the Rera, because it is a regulatory, and I have to Rera tell that okay, you need to please check that this is a 51% already sold, because I as a buyer I go and check every day that how much the developer has sold, and he has to update it on website that what are the inventories being sold. The moment I check that it is more than 51%, I will tell Rera, sir, please, why don't you ask him to form an cooperative society or condominium or maybe a company. Then under that case scenario, my complaint is not fitting under section 31, or because it is a regulatory powers of Rera, where I am telling the Rera, please franchise those regulatory power and decide on the matters on that on bona fide. So there are some certain scenarios which the the Honorable Bombay High Court thought was that of course you are having a suo moto powers, but then you cannot just depend on suo moto powers only. What if you do not have a suo moto notice and given us the relief? Then what would be the people, those who have aggrieved in this regulatory framework, which is not fitting under section 31? Where do they go? Neither they are having a respite in section 31, nor they do have a or they just wait for the suo moto action where the Rera will take. So under that situation, now the Honorable Court has given an advice to Rera, and the Rera very well taken it, well drafted document, and it is for everybody because it is very easy to. It is there. It's a self-explanatory. I'm not explaining the Annexure A and affidavit and the other procedure because it is self-explanatory. The sooner the later, Rera, we know that very much tech savvy and going to come up with the separate online you can submission of such type of grievances to Rera, which is adversarial litigations and not coming under section 31, and suo moto where the Rera would have actually taken. I'll give you some example of suo moto also. The suo moto, remember, it was the very first case in the history of Indian Rera, where Maharashtra Rera on 5th June 2017 taken a very first case. That was a suo moto actually. It was a regulatory suo moto where the erstwhile chairman actually seen some big holdings of some broker, and then sent one notice to the broker and fined him that okay, you have not used our website, or there were some issues in the holdings, and then there was no registration numbers of the projects which were displayed. So that was some so and then there were n number of developers who got the penalties, those who have actually not published Rera's website on their advertisement, or maybe published advertisement without the Maharera registration number. So such type of suo moto, which we know came to know that these were the suo moto actions taken by Maharera. Now, since the adversarial litigation under Order 29 is there, any person who think that there is a regulatory procedure should have been followed by some people, and if it is not, then you can always file telling Rera that this is your power, this is your regulatory powers, you please adjudicate or fine or make people adhere to the regulatory framework which the Rera Act has come up with. So with this, I open the forum with all questions and answers, and all my learned friends also can participate. President, sir.
Yes, Sanjay bhai. I think the subject is new, and we need to have some research on this subject. What kind of scenario? Like I was thinking, there could be a possibility where allotee to allotee complaint cannot be filed under Section 31 for some matter. Say, for example, choice of the form of association of allotee. It could be condominium, it could be company, it could be society. So here also there is a scope where we can go, we can take the benefit of this order. Friends, I would request everyone to keep their video on now. Keep your mic on mute only whenever you want to ask any question. And now I will request Satish Dedia, our Vice President, to lead the query session. He can put his input. Satish bhai.
हाँ, अश्विन भाई. Thank you, Ashwin bhai. Dr. Sanjay Chaturvedi ji has explained the topic, which is a very new topic for us, and in a very short period, he has compiled the all relevant points to enlighten us on this totally new topic. Thank you, Sanjay ji, for your hard work. I am just briefing some points which may require repetition of points which you have already discussed. What I understand that this topic is related for filing the complaints which are not complaints under Section 31 against the promoter for financial issues, and these complaints are related to the registration related issues which cannot be solved by filing complaint under Section 31. Sanjay ji, is it right?
Yes, there were some other issues, but because of the time shortage, I could not explain my other slides also. But
No
if the question comes in, we will just take those slides again and we will explain them.
Sanjay ji, can you just explain us the difference between a source complaint, which was also by virtue of a High Court order, the Rera had initiated, and again this is also again one more writ petition against which this has been done. What is the difference between these two?
See, basically a source complaint was that the project should have been registered because there is a live IOD-CC was in place, and that was also initial time in 2017 where many of us had an interpretation that okay, I am not supposed to come under the Rera regime because of I am not going to sell it, or I am just going to lease the entire project, so I am not going to put it, or maybe there was some order of Maharera in Sejal Gandhi case where the Rera have taken view that you need, if suppose the project is occupied or the project is already given possession, then and the OC is not received, then you don't need to actually go and register your project. So under those pretexts, now it is almost over that the source complaints are very hardly to come. Of course, it can also come in Order 29, the source complaint, but now there is a new mechanism. will also be guiding under the source complaint also. So of course, source complaint means one portion or some one part of this order 29. And it is, yes, definitely the source complaint is also need a regulatory attention, which any person can go and tell the Rera that it should have been actually registered. You are right, sir.
So now, under the source complaint, we were required to pay 5,000 rupees fees. Now, under advertorial, are we not required to pay any registration fee, rather
Yes,
complaint fees?
we have to come and see that if suppose the Rera was to have some fees, which will be definitely going to be there. So I think let us wait and see for the Rera to come up with, if suppose you want to have a fees for this.
But right now, there is no such guideline about the
No,
fees.
no guideline. In order 29, there is nothing written actually.
Sanjay bhai,
You were just saying that promoter, the dispute between the promoter, you think it can be taken if there is a change of promoter and all?
Yes, absolutely. Yes, that's section 15. You can always go to the Rera.
See, can we have a discussion on this section 31 aggrieved person? Am I audible?
Yeah. What is your
yes.
question?
So concern is that it is written aggrieved person. So if aggrieved person, it is apart from that allotee or promoter and agent, anybody files, then it's become a public interest litigation. So I think in Maharera also there are various judgments which say that if you are not allotee, then you cannot file the complaint. So can we have some discussion on these points? Because the aggrieved person is not defined under the Rera. So any any judgments or any interpretation from the other point of view, because this is my personal view that aggrieved person should be allotee, promoter and real estate agent only, or either association of allotee. So
No, it's not like that. Aggrieved person is aggrieved person. I have filed, maybe my friends also have filed. Even a vendor has filed a case on project on the developer. Even a broker has filed a case on against the developer, or a person who is a landlord, or maybe a society of who are having an SRA project have also filed the matter under section 31. So the section 31, the scope of section 31 as an aggrieved person is different than regulatory procedural. The order 29 is having a difference between section 31, and very specifically they have mentioned
no,
that
I'm not.
other
My question is not related to this order 29 specifically. My question is that's why I asked, can we have a discussion on that part also, if time permits? Because it is ultimately relevant to this part. That's why I thought.
So you
Sanjay bhai,
saying that you are eligible under section 31. You are saying that?
no,
I'm
Sanjay bhai, his question is, section 31 starts with the wording any aggrieved person may file a complaint. Now his question is whether in this aggrieved person can we have a banker, for example, because he is neither a allotee nor a promoter nor a real estate agent nor a association of allottees. So these four category, apart from these four category, can anybody else file complaint under section 31 though he is aggrieved? That is his question.
Yes, because I'll give you example of Mumbai Grad Panchayat, who has filed the case against the 99 acres that they become a broker. So under section 31, anybody who is actually aggrieved, they can file it. But this question which I have given you the example, now they can come under order 29 also. And in order 29, very specifically it is written that any aggrieved person which is having a recourse in section 31 are not going to be taking a recourse of order 29 over here. So there is a bifurcation. Order 29 is for regulatory powers, and section 31 basically for under section 12, 18, 14, 15, 17. These are the sections under where the section 31 is eligible.
No, the example what you have cited, Sanjay bhai, Grag Panchayat, for that particular website, they are not registered as a agent. That is the case. So now this case can fall under both the category.
No, this case can fall under order 29. That is where I have given the example.
So prior to 29, this case never fall in any of the category, 31 also?
No, that is what I am saying.
That
Because
is my question only. That is my question. So, sir, that is my question. I want, because we are into the Rera practice. So I want to, I raise this question because there are various cases which is filed against the promoter. Suppose example, I had an agreement with the landowner or the promoter. Now there was a dispute between the landowner or the promoter. So that agreement could not be executed, right? And now the this land dispute on the land, which is a part of the project which is registered. So I say and I file the complaint. So there are various judgments where it is said that you are not the aggrieved person. You have no concern with the this project. So you cannot file the complaint. So the question comes, how that would be taken care. Please ignore the order number 29. So if we have concluded this order 29, then we can discuss this part, or any another session we can take. Because there are two issues which which is coming into my mind. First, this is the section 31, and another important issue is related to allotee. So suppose another question comes into my mind that I am a prospective buyer. I go and I give a booking amount of ₹5 lakh for a project. Now, section 2D of the allotee says that the allotee means the person to whom a flat apartment is allotted. Now, when it would be allotted? Once the promoter gives the allotment letter, because I paid ₹5 lakh, but the promoter has not given me anything. So he said that you can choose any unit. So nothing specific unit is there. So will I become allotee? Can I file the complaint under section 31? So these two questions I want to discuss on this forum if time permits. Otherwise, we can have another session on these 2 points.
We'll take up just to be finished with the order 29.
Yes,
then we will.
yes.
Yes. Sanjay ji, I am putting this question in a different way. Sanjay ji, according to the this circular number 29, all the complaints which can be decided or came up before the authority, regulatory authority under section 29, whether it is related to regular website related issues, whether it is related to registration related issues, or whether it is related to the functions of the authorities under section 32 or 34, all such issues wherein no financial relief is sought, but the person is aggrieved or not aggrieved. But if there is a question related to these sections, can be now taken up under section 29, like even like we can treat it as a PIL, right, Sanjay ji?
Yes, order 29 is basically for regulatory, litigation, adversarial litigations, where onus is on you to prove it that there was some regulatory indulgence required by the Rera, that there is some flow. There is the regulator must understand. If it is not suo moto, then I am telling the Rera, saying that please understand that you would have actually taken a notice of that flow in the regulatory sections. Now it is I am taking and bringing to your notice. Please do this. So this is what that thin line between order 29 and section 31. Basically.
Right, sir. Sir, we will take up issue of Nachiket ji, and then thereafter I will ask some more questions. Ashwin ji, please unmute Nachiket ji.
Thank you, sir. Thank you so much.
Yeah.
I would like to know whether like an allotee can file complaint against project professional using this order 29. For example, if an architect is saying that the drawings which were submitted to municipal corporations and the work which was undertaken as a project professional by him and actual delivery doesn't match. For instance, let's say they have asked for carpet area of 70 meter in agreement, and on site actually the carpet area which was delivered is 65 square meter. So this was responsibility of project professional. And in that case, can allottees get any kind of help through this against project professionals?
I don't think so, because the onus is on the promoter to produce the professional certificates, just like it is form number 1, 2, and 3, 4, and 5. So these are the forms which needs to be given by the professional people on the request of or the engagement of the promoter. So you have to file. If suppose you want to, then you cannot directly put a professional into regulatory this. Regulator don't have any power to regulate these professionals, but they can have a question to the promoter itself. So if you have some question, you can always file a complaint under Order 29 against the promoter, not the professional. Or if suppose you should have some problem,
but can we ask Rera?
Be, approached.
Can we ask Rera to set up a responsibility of professional for misguiding the allottee as well as the Rera?
No.
Some liability should be set up against project professionals.
Yes, that issue can be taken up.
Yes, Nilesh bhai want to say something on this.
Yes, Nilesh bhai, please tell.
I can answer that very quickly. Since the project professional is acting on the instructions of the developer, under 37, the authority can direct the developer to rectify, put conditions under unfair trade practice, revoke and issue penalty.
Correct.
Citing that the professional which you have opted for and information provided by you is wrong, false or misconstrued, and therefore the developer will be liable, and there can be a finding given against the project professional, and that can be appropriately taken by any aggrieved party before that professional who is practicing there, like bar council, if he is a CA, before the ICWA or whatever that body is. But you, Rera can't assume jurisdiction over all of this. But obviously, developer can be penalized.
It has happened, Nilesh bhai, in one of the architect case, I think. The matter was then referred to the Institute of Architects.
Correct.
Now, can we make architect as a respondent along with the promoter?
No, in 38, the power of authority is that they can be issued witness summons and call for evidence or recording his statement. That's it.
Okay.
In one of the case, Rera has appointed a technical officer from the Rera to visit the site and report back, and then the Rera has the step of this in the
that power is given under section 35 also, to call and summon any person.
Yes.
That is witnessing the professional. So, Sanjay bhai,
Yes.
is it that now Order 29 has opened the door for PIL type proceeding, even though I do not have any interest in the project? Say, for example,
No, it is only for regulatory.
On regulatory only. Suppose you have booked a flat in some project, and I am nowhere concerned, but I came to know that there are some regulatory non-compliance, some violation. So, as your friend, can I go? Because you are not going. I want to save you. Can I go under Order 29 and do that? That is my question.
Of course.
So,
that is a person who do not have anything, just
any
like
interest. Yeah.
I think that we need to take a clarification from Rera, because you are not, even High Court asks you, sometimes you file a PI, then what is your personal interest in this? So you need to.
Here it is a little difference. In a PIL, court will first check whether you have a personal interest. If you don't have a personal interest, then it is public
Then
interest.
it is allowed.
So therefore, your application to Rera will be actually having more weightage than a person who is interested.
Correct.
Yes.
So it will open a new Pandora box for the persons to claim some undue advantage.
No, but actually my reading of suo moto is a little different, where the authority themselves, without any information, takes a cognizance based upon any information or someone providing, say that he is in violation of X provision.
Yes.
Let's say that someone publishes a banner without Rera number, or gives a public notice in newspaper selling some apartment without Rera number, website, or what is mandatory. Then in suo moto, if there is an information provided, Rera will take cognizance, but no hearing will be granted to the person who is not
informing the
any way
Rera.
connected to the project.
Correct.
It will only mention that we have received information and we are taking suo moto cognizance of this. Like in case of labs project.
Let's take the questions. Shreya, are you having some question? Shreya?
Sir, whether the deregistration of the project is covered under section 29?
That is where this order has come. That deregistration was never actually provided for, and that is where now the Rera will have its own course of action. It will be having a mechanism to deregister or alter or modify the projects.
So it is not covered in 29.
Yeah, maybe wings, maybe face, maybe some other.
Sanjay bhai, this deregistration is not provided under central legislation, correct?
Correct.
Now,
correct.
can order 29 be invoked for something which is not provided in central registration, which is not a regulatory framework? Because once the project is registered, third party rights are created, then can a promoter go and say that I will refund the money with interest? Simpler, because there can be n number of issues. Can that happen?
Yes, because see, I tell you, the revocation of the registration is there already. So revocation can be either somebody is by yourself you are telling the Rera please revoke it, or maybe somebody else, or Rera wants to say that okay, you are telling me to revoke the registration, but I have to hear the other parties also, no? So for that purpose, for the regulatory form mechanism, the Rera will take the matters like this, and it will be revoking.
But Sanjay bhai, revocation will not end the project. It will change the hand of the project. By revocation, the project gets change of hand. Whereas by deregistration.
No. Revocation is revocation. That means it is deregistration only.
No, revocation. See, once the section 7 is triggered, then under section 8, authority has to find who will complete this project.
That is on the pretext where the buyers are telling the authority to find a new developer. It is not suo moto. It has to be coming from the buyer or the aggrieved person, that only under section 8 then the authority needs to tell the appropriate government to replace the developer. So it was not like that. It was basically a revocation is that it is provided in the Central Act, but it is now formalized under this Order 29.
Sir, but even section 7 subsection 3, even it says that instead of revocation they can put some additional conditions. So why somebody will go and why somebody will go for the re-registration? They can ask.
No. It is just like say DB Realty wanted to deregister it actually. So it was not that. It was section 3 was just to maybe change of hand, or the buyer wants to take off the project, or they want to have some transparency or whatever it is. So, but then it is two different things altogether. What we are talking over here is that we want to, as a suo moto, I just go to Rera saying that please deregister my project. I don't want to continue with the project.
Yes.
Like
Satish bhai, there are some show of hand. Can you tackle that? Yes, Sunil Keval Ramani, you can ask the question.
Hello, sir. Sir, my question is that now there are many developers who have not done the compliance orders issued by Maharera. Like they have not uploaded the disclosure of inventories. They have not uploaded Form 5, etc. So can we file a complaint under this order for disclosure of inventory? Because this disclosure of inventory is very important in some cases.
You're right. And this will be happening in this basically. I will ask my developer to have some material disclosure. And now you are saying the latest circular of Rera, which is saying that now I am going to display, except the CA certificate, everything else will be in the public domain. So you can always go and vouch. If suppose the developer is not doing the thing, you can always go to Rera and say that, okay, please ask him to have a regulatory. You're right, absolutely.
So then I think allotee doesn't need this order 29, or allotee can also use this.
Anybody can go. Anybody.
Sir, Sanjay ji, actually, sorry, as per section 31, if point is covered by violation or contravention, then it can be filed under.
Yes. So anything which is coming under 31 is not covered under Order 29. It is very specifically mentioned.
Sanjay ji.
So you can have under, if suppose there is a respite under section 31, when you can file, and for the regulatory thing, you need to go there only. You are right, absolutely correct. Satish bhai, you are right.
So Satish sir, you are saying that allottee cannot ask for disclosure of inventory under section 31?
No.
Okay.
He has to file complaint under section 31 because it is violation or contravention of his rights or duties of the promoter.
So then Satish bhai, all the regulatory compliance are the violation of the rules and regulations.
No, as Sanjay ji told that suppose there is a issue in the system or correction in the already application is done. In that cases, as of now, we were doing emails and so on, and so Maharera was not considering. So under this framework, they have provided a proper mechanism to entertain all such complaints. Correct, Sanjay ji?
Correct. You are right.
Yes, Aditya, you want to ask some question?
Yes. So basically my issue is with the entire order itself. My first question is that they have given a title that filing cases arising from regulatory functions of Maharera. Okay. But later on, what they have decided, regulatory matters that take the form of adversarial litigation shall be filed in manner. So who will decide this adversarial litigation first? Next is, once I file, I do all the formalities, I file this forms and annexures, everything I file. Later on, they will intimate me defects, they will point out defects. There is no time given in this particular process. Next, there are already 5,000 approx cases orders pending. So in this case, what will happen with this procedure? Because here, there is no mechanism. If now how you give the sections in the slide, that these are the regulatory function. So why Rera didn't give the section itself in this order that if the matter is pertaining to this section, then they can have a recourse under this particular order. So it would have been a proper way, because if I as an allottee or as a person, I am deciding that I have to go through this order, and later on they decide that no, it is eligible for a suo moto and not an adversarial litigation. So the entire process will involve a lot of time, and there is end result will be that there will be a dispute that it is a suo moto or again a adversarial litigation. So what is exactly the issue with this? Why they have come up with a procedure wherein no timelines are fixed? And again, if the secretary, we are not happy with the secretary, they have given here that secretary might give certain details here and he will point out certain objections. And if we are not happy, then again we have to go to chairman. So they are increasing the steps here instead of reducing the litigation at the initial stage itself.
3-4 questions which you have asked. I will answer you the last question first. First is that this is a usual procedural thing, that suppose there is a objections came up with, you should not you should put annexure this like this way, or you have not signed, it is not notarized, or it is. So this is basically a defects in your application. If suppose you are not satisfied with the objection of the secretary, so they have given you a, you can say, mechanism to just announce to the chairman saying that, sir, this is why I am a powerful attorney, or the main person could not sign, or whatever, you can give the reason for this. And for that reason or small thing, you cannot go to the tribunal or to high court. That is why the mechanical, you can say, procedural for this is. The question between the difference between a suo moto and the adversarial litigation is this. What the writ petition said, that since if Rera suo moto not doing it, then you please go and tell the Rera, say this is what you should have done it. The Rera don't know whether your land has been acquired by the railways and there is a material change in the layout. Rera don't know unless you tell the Rera, sir, please see that my now project is now 18 एकड़ का था, अभी वो 12 एकड़ का हो गया है, but because of that now I want to change the layout, or I want to change this, but now since the buyers may not give me the permissions, or I need to inform the buyer, or I had informed the buyer, and all the procedure I have taken care of. Now please give me another you can say enhancement of commencement certificate, or maybe some other or I want to get rid of phase number 3. Now I will be only confining myself to phase number 1 or 2. So Rera don't know what had happened to you. So you need to give Rera that this is the information. So that is adversarial litigation. That means onus is on the litigant to tell the Rera that this is a regulatory power you must franchise on me, and I have satisfied all the regulatory framework. I have satisfied all the people those who are being affected. And if you wish, you please call them in the hearing and ask them whether I have paid them or I have satisfied them, or these are the affidavits which I have taken from them. And you can take on testimony whether, and then pass me the order, and reduce my phase, or modify my layout or my this. So basically a development telling the Rera that you should have actually suo moto taken a permission, which you did not. So I am coming to you, and you please now give me the respite. So this was actually the gist of that writ. That where the DB Realty wanted to deregister it because of whatever reason, maybe they not gone, high permission not given or whatever it is. So now it is not possible for them to construct. And then if the project is not viable, if they don't go with a certain height, and they want to just discontinue the project, instead they may go for some cluster redevelopment, or may they go in some other scheme or some other concession after deregistration. They may go for some other respite of the project, or they may take some other partner or sell altogether the project to somebody else. So this is what under regulation, the whatever not falling under section 31, we need to tell the Rera that okay, please give us the respite under your regulatory reforms or regulatory powers. This is the difference between suo moto and adversarial litigations.
Okay, sir.
Yes, Nichiket.
Sir, Sanjay ji.
Yeah.
So if now the authority is not doing or discharging its functions under section 34, so now any person can bring it to the notice of Maharera and file a complaint under section 29 for discharging those functions. Like non-registration, as you already told.
So that any person should not be a person interested, and if it is interested, then it should come to under section 31 only. So that is where my friend Nilesh Bhai have said already that you need to first prove that you are bona fide, whether you are eligible to get regulated by yourself, by the regulatory authority.
So Sanjay Bhai, now those persons who are interested, they will go under 31. Those who are not interested, they will go under order 29.
No, I'll tell like this way, that if suppose there is some respite which is there in the act and the Rera is not giving me.
Yes.
So I have to tell the Rera, say, sir, please give me a respite under the act as if you are a regulator and under your regulatory powers. Now please confer and give me my respite, and there where I can go.
Give me my respite means again you are talking of interested person. I am saying I want to invest in this project, but looking at the compliances, he has not done and you have not done as a regulator, you have not levied some penalty, whatever, XYZ. Now can a prospective buyer go under order 29 saying that he has not uploaded sold unsold inventory? How can I find out whether the proposed flat which I am going to acquire is free from all encumbrance?
Sir, I'll put it like this. If suppose I am the only person and the other party is Maharera. So if other party is Maharera, I cannot file a case against me only under section 31. Suppose I am a developer and I am having some, in my project, there is some which is, I need some regulatory attention. So under section 31, I cannot file a case against me only.
Correct.
So I have to go to Rera and tell that you are my party other than, because you are respondent, you are regulator. you need to give me a respite. So there where I go under the regulation. So there is a difference between 31 and 29.
So then does it mean this order 29 is the door is open only for the promoter?
Almost. Promoter or maybe a landlord or promoter.
Whatever, means promoter category.
Yes.
Promoter category, basically.
Yes. Correct.
Sanjay ji, suppose we now wish to make as an association, wish to make an representation as we regularly submitting. So is it possible now for as an association to make a complaint and request the Maharera to consider our submissions on various points, whether it is related to procedures or circulars or otherwise?
Sir, the
Under
Maharera
section
is the
20.
regulator and the Maharera is the executor of the act. So if suppose there is some suggestion, he'll say that please go to the government and tell the government to modify the act or the rules and regulations. So if there anything rules and regulation में जो लिखा है, I am going to just franchise that. The regulator will not listen to you, and may they say that okay, yes, it is a very good idea, you must do it. You can also go to government, and I will also tell the government, please modify the rules and regulations. But
for example, sorry. For example, the deadline of statutory certificate as to submitted is near and due to some reasons. For all or in a general, it is not possible to comply with that obligation. So as an association, we can move to the authority under section 29 requesting to extend that time. So such type of issues now can be taken up under section 29. My question is this.
No, because Rera itself cannot regulate itself. It is being regulated by the Act and regulations. So, which is not there in the regulations, then Rera will not entertain it. You say that okay, self-imposed discipline. I am not here to make rules. I am here to execute the rules. So if there is a deadline, you have to adhere to the deadline. I can just say in Maharera, what I did, there is a difference between Tamil Nadu Rera and Maharera. The Tamil Nadu Rera said nothing doing. Whatever the dotted line as a model agreement, you have to just fill in the gaps and execute the agreement. But Maharera gives the respite in the model agreement to be changed according to your whims. Or maybe if suppose in Karnataka Rera, if the CC date is say December 2022, so you cannot have an extension of the project in Maharera for December 22. So they'll say you adhere to whatever the permission of local self-government has given you. You cannot go beyond that you can complete the project. The Karnataka Rera says, but Maharera has given you the respite. So every Rera, which is because housing is a state subject, every Rera has its own rules and regulations, which is actually passed in Vidhan Sabha and it has been notified and gazetted. But to have the alternation to the regulation and rules, you need to go to the state government and say, okay, sir, please. Yes, Maharera gave one respite. That was suppose it was written in that the banker should be given all the forms before you withdraw under that 70% dedicated account. The Maharera said, okay, one declaration you give to the banker that you have procured it. But it has not exempted you to not to take those form number 1, 2, and 3. Maharera just given you, okay, the banker just to reduce the procedure. But it has not waived off that particular thing. Again, the Maharera came up and without 1, 2, 3, you cannot withdraw the amount. Now you need, and all the bankers now asking all the forms now. So recently the circular has come up.
No.
So it cannot go beyond the power.
Sanjay bhai, now what Satish bhai has raised the question, particularly form number 5, annual audit report. This representation we have done before the earlier chairperson also, and now this chairperson also. What the earlier chairperson used to tell is that there is no power given to us under central legislation for extension. That is question number 1. The current chairperson, we asked for March 22 because the income tax deadline also was for March 22. But he gave up to some January 22 or December 21, whatever. So here, can we invoke order 29 since the Maharera is saying we do not have power? can we make central government as a party here, saying that this is to be looked upon?
No, because I tell you one thing, sir. The Act says 6 months after the closing of your balance sheet. Let me suppose 31st March you closed it, and 6 months is the basically this. So till September, usually we usually take 6 months to close the balance sheet, your tax audits and all that. After the tax audits, you have some certain period where you need to file form number 5. The Rera cannot actually amend the act itself. Rera can give you some respite, saying that okay, because of the COVID reason or because of all the force majeure and all that, people were not completed. And you rightly said now it is March 22 was the completion date of the income tax. So whenever there is a last date of the income tax, from that you need to have 6 month time, which is there in the act itself. So why to ask Rera any respite?
No, Sanjay bhai, under act it is like this from the close of financial year 6 months.
Yes.
Now central government is extending my timeline under direct tax.
Correct.
But
So
Maharera is saying that we don't have power under that section 4.2 LD, which says that from the close of financial year 6 months.
So we have to educate Maharera. It is not, see, the onus on the...
No, we have given representation in writing. I have given 2 letters. So somehow I got up to January 22, but the current chairman, even without discussion, he was not ready to give any further extension. I discussed the same thing with secretary. He was convinced. He said, yes, since the central government has granted in income tax, this should also follow here. But somehow it could not happen. So my question only is whether I can invoke order 29 here in public interest.
Sir, my humble understanding is this, that any or regulatory where if suppose somebody is fined for not filing form number 5, then we can take it in the PIL format or whatever, or in the read format. Otherwise, you can always tell the Rera that this is what written in the act, that after the and the income tax already have announced the date. So I got 6 months after that. So you have to regulate. Of course, you got every right to regulate it, but the act has given me the power to announce the date. You have to make understand the Rera. That's it. Nothing else. You cannot ask respite. You cannot say, sir, usko extend kar do.
Yes, Satish bhai, anything?
Mr. Nachiket has raised the hand.
Nachiket, I think.
Do you have any question?
Yes, sir. I do have a certain question. Like as said in earlier discussion, that the Rera number should be printed on the advertisement material. So every promoter is giving allotment letter or receipts of payments or some other material on their letterhead. Does that advertisement material consist of all these certain other documents? And the Rera number should be printed on them or not?
Nilesh bhai will answer this. Nilesh bhai?
It's a very good question, Nachiket. According to me, in allotment letter or payment receipt, there should be project number to be informed that this money is received towards that escrow account, that project, that flat. Okay. It should be standardized, but there is no cognizant till date which is taken. In the model form of the agreement, Rera number is projected. But as far as allotment letter, there is no strict rule or such mandatory. But Supreme Court has now taken up one issue of standardizing model format of the agreement and allotment.
Right.
So this will come in near future.
Okay.
Because what happens is many times entries or loan transactions are given, and these allotment letters do not bear any CTS number or proper name. So the project number will crystallize it.
Right.
Nilesh bhai, just to add on this allotment letter, Maharera is under process of giving one draft allotment letter whereby they want to streamline the forfeiture clause. So there,
What is the forfeiture clause? They are concentrating on only forfeiture clause, but see 13. 13 says that you have to give proper exact dates of when the slabs will be casted. If you see 13, the agreement for sale, I'll read that. The agreement for sale referred in shall be in such form as may be prescribed, shall specify particulars of development of the project, including construction of building, apartments, along with specification, internal development work, external development work, the dates, the manner in which payment towards that cost of apartment or plot, or that as the case may be, the date on which possession of the apartment, the rate of interest payable by promoter to the allottee, and the allottee to the promoter in case of default.
it says particulars of development.
No one reads.
No. It says particulars of development and which specification.
Correct.
The date. So one part is this particulars of development. Now, does it mean you have to give the date of first slab, second slab, third slab? One thing, Nilesh, right? Second, it says date and manner by which payment is to be made. That is another thing. See,
So
there
both
are
are interconnected.
No, not necessary. See, I can have my payment mechanism on periodic basis. I can have that. Okay. After 2 months, I will collect this much. After 4 months, I will collect. Now, what you are referring is particulars of development, whether that covers period to be mentioned or not. That is the question. Your question is that.
Because the date of possession is mentioned for completion.
Yeah, date of possession is mentioned. Date of possession is mentioned.
Including external development works.
Yes,
if
yes.
it is a layout,
yes.
then my amenities also get included.
Correct. But
so my amenities can be a future date. But
because,
that date has to be specified.
Because if you look at model agreement, the very first transa says that you can amend this model agreement within the four corner of law.
Correct.
Correct. So there I can have payment based on periodicity, payment based on a particular achievement of the task and all these things. Correct. Or I can have a lump sum payment also.
Payment. The forfeiture clause also includes that interest payment. The rate of interest payable by promoter to the allottee and allottee to the promoter in case of default.
Yeah. So that has to be there. That is there. So I cannot change interest rate.
Till date, Rera has not considered this section at all. That's 13.2. While deciding a complaint, if there is an agreement which specifies 21% of interest, then it is not prescribed interest as per the agreement.
No, but then that clause in the agreement would be inconsistent and will not hold good. 21%.
No, see interest, the definition of interest. It says if parties agree on a higher rate, then it has to be higher.
Under rule?
No,
under rule 19.
And for the same, what
it
you are
is only when there is no rate of interest prescribed in the agreement, then as per the Rera prescribed it.
You are referring to rule 19 of interest rule?
I am referring to definition of interest. Please see in
Act.
Under Act.
Under the Act, which
Sir, I would
2ZA. 2ZA.
1 minute.
Sir, in the meantime, I would like to add something.
For both the person, for builder and for the same interest rate will be applicable.
Correct. Right. Rate of interest chargeable from the allottee by promoter in case of default shall be equal to the rate of interest which the promoter shall be liable to case in the default. So he can't have one on default developer say I will charge you 21% and you will get only Rera prescribed. It is equal.
No, but Nilesh bhai, clause 1 says rate of interest should be equal for both the parties.
Equal.
Right. 1 minute. Then rule 19.
If it is not mentioned, then
rule 19. It does not say if it is not mentioned in agreement. But rule 19, if we go, then it says the interest shall be SBI MCLR plus 2%.
Right.
No. Rule cannot override the act. You have to.
No, but act does not say like this. It says that this particular interest, whatever Maharera is saying, would be applicable to both the parties as per rule.
If in MOFA there was 21% on default of allottee, same interest is applicable for developer to be paid under 13. That's the question.
Correct.
That is 13. If you say that in case of allotee defaults, he will charge 21% in MOFA agreements. And in 13, if you have prescribed a rate of interest, that will be applicable as per 2ZA for the promoter also to refund.
I will read rule 19, Nilesh bhai.
The rule is when there is no interest prescribed.
1 minute. Rule 18. Rule 18. The rate of interest payable by the promoter to the allotee or by the allotee to the promoter, as the case may be, shall be SBI MCLR plus 2%. This is what Rule 18 says. Nilesh bhai.
See now, read 18 proviso. That where an allotee does not intend to withdraw, he shall be paid interest for every month till handing over at such rate as may be prescribed.
So prescribed means Rule 18. Prescribed means Rule 18.
No. Now prescription is 13. What doctor writes in your prescription that you will get crocin or decold in
No,
case
but
of.
see, the 13
Now,
agreement cannot be
is,
prescription. It is the terms of contract.
So there are two things. If the terms of agreement is silent, then prescribed as per MCLR, the rule. If it is expressly written.
I think there are many judgment on this, Nilesh bhai.
No. They have not even dealt with 13.
Many allotee while claiming the relief have asked for 21%, 18%, but they have not been granted.
It's different thing. Sir, today I may be just if the host can allow me to share, I will share one order of tribunal where it says after having more than hundreds of judgments saying that with OC Section 18 applicability does not absolve. It has categorically, tribunal has said in the Vadwa matter right now, saying that the authority is not looking at the orders. Just 1 minute, if I may be allowed to share that order. And the authority has been doing this. We might ask 18%, 21%, but have we argued this? 2ZA, 13. This question of law has been not taken.
This needs to be deliberated.
Canvassed by us. Now, just see this. Just see this wording. It is so. Sir, just allow me to share the screen. And it is uploaded today only.
1 minute. Yeah.
A beautifully written judgment.
Now you can share.
The learned chairperson of tribunal. So, for the above, can we see it?
Yes.
Yes.
For the above reasons, we answer the point accordingly and outrightly reject and disapprove erroneous view taken by authority in the impugned order that Section 18 would not apply on obtaining OC or completion of construction. Such kind of stereotyped view taken by authority in several cases has been consistently set aside by the tribunal. Also in the case of Suryakant Jadhav.
Yeah, that is.
So the authority has been doing whatever it has to be, but no one has taken up this point. Even after a tribunal giving such direction, authority says that after OC, no 18 is applicable.
Yeah. Can you stop share, Nilesh bhai?
Yes.
Yeah. I think Satish bhai, anything else on the today's subject? Because Rera is such a subject. We used to take a divergent, दूसरे track पे जा रहे हैं, but it's an interesting discussion because each sections are interrelated, each order circular. So we don't know which. In one of the case, I am before the tribunal where the learned chairperson has not gave me a relief that landowner should be taken as a promoter. But in the operative party says that both the respondent are liable for completion of the project. Now I am arguing Section 37. Under Section 37, the direction can be given by Maharera only to 3 category of person: allotee, real estate agent, and promoter, not to anybody else. So I am saying that these are the direction. Hence, it is automatic promoter. So this kind of argument we can certainly make. Yes, Satish bhai, anything?
Suo motor, I would like to just highlight the suo motor matter has arisen from the DB reality matter of writ petition. And very recently, the appellate tribunal also in the matter of Mangal Bilkwan, where there was no complaint, but it was suo moto. If everyone has seen, I think it was shared on the group also. This order records that there was suo moto proceedings, although there is a complaint number also, but there was suo moto proceedings where the subsequent registration came to be cancelled. And the appellate tribunal has confirmed the view, rejecting the interim reliefs of the new developer.
Yeah. So, Satish bhai, shall we conclude or anything you want to add?
Yes. Ashwin bhai, what I
We
request that
should
this is a
also,
new subject.
for the forthcoming subject and webinar, we should announce today, Satish bhai.
Yeah, we are
One
planning.
Is today visible? It becomes very difficult to trace Satish bhai today.
Ashwin
Yeah.
bhai, what I
Bolo.
suggest that this is a new topic. So if it is possible, we can request the Secretary Maharera to have a conversation either on the general conversation on Zoom or to the representatives of association, wherein we can pursue him to take up various matters under Section 29, so that at least the registration part related issues, which are otherwise not addressed properly, can be now taken up under Section 29 properly.
Order
So
29, Satish bhai.
Order
Order
29.
29. Yeah. Yeah, certainly we will do, we will talk to secretary and try to have a one-to-one meeting on this. And we will also take Sanjay bhai also with us, because we can point out various matter, whether this can cover, this can not cover. And let's have a good discussion on that. We can certainly do that. Now, coming to the next topic in the month of May, we are planning a webinar on, there are many issues, but we are more now concentrating on the issues of the stalled project, how to convert stalled project to a reality. Now, this can also be one question under Order 29,
Correct.
which we can raise before the authority. So we will certainly, as Satish bhai said, we will talk to secretary and even chairperson also on this. Okay, let's there be a meeting of the professionals so that there are no unnecessary application going under Order 29. Otherwise, as Aditya said, already they are busy with 5,500 complaint, and again there would be some 2,000 application under Order 29. So that should not happen. So very intent should not get defeated. Okay, friends.
Also, if possible, keep a seminar on how to file a good complaint.
Okay, sure. Well taken,
Because
well taken.
we professionals keep on filing complaints. Some grounds are taken up, some grounds are rejected upfront. So in the first place, if we start filing good complaints, then there will be saving of our time as well as the time of Maharera.
Correct. Certainly, we can do that. We have many learned advocate in our committee also, and as a member also. So with this, now I will request our secretary Nilesh Gala to propose the well-deserved vote of thanks to Sanjay bhai, who has taken our request and burned midnight oil and came out with whatever he can give input on this order number 29. Yes, Nilesh bhai.
Firstly, I would thank today's speaker, Dr. Sanjay Chaturvedi, which folded hands and on behalf of all the members here for accepting our request, and within a very short period of time, we had a meeting of our committee and he volunteered and he's ready with the subject on request of our president. And of course, with all our committee members, Aditya, Satish bhai, Ramesh Prabhuji, and I thank each and every participant and would request every participant to be a part of us and give suggestions as Nachiket has given today, including sending us emails with brief note on what is the subject which you would like to take up, and we will be discussing in our committee and taking up those issues. Once again, thank Dr. Sanjay Chaturvedi for his precious time, and we request that Dr. Chaturvedi will continue to do this kind of webinars for us and enlighten us. And of course, all of us will jointly work towards this. And I request immediate President Sir to take up this issue immediately of having section 7, 8 and 15 stall projects with order 29 as a core issue for May with developer community and a physical webinar.
Yes.
Physical seminar.
Yes, certainly. Now, so far as request to Sanjay Bhai is there, I believe it is suo moto. We need not give request. It is suo moto. Without any adversarial litigation.
अच्छा संजय भाई, ऑफ द रिकॉर्ड एक सवाल है.
ऑफ द ये सब रिकॉर्ड में है. रमेश भाई ये सब रिकॉर्डिंग हो रहा है. It is nothing is off the record.
अच्छा, ऑफ द सब्जेक्ट. चलो ऑफ द सब्जेक्ट. अभी Rera, whenever there is a jurisdictional issue, whether arbitration or Rera. So if there is an arbitration clause, Rera chairman says arbitration will prevail. So because it is a jurisdiction issue, can we straight away file a writ?
Absolutely, we must, because in NCLT also there is one judgment, and I'll just give you one very simple, you can say, answer to this is that, see, section 88 says that Rera is in addition to and not in derogation to any other act. So everything is subsumed. And in the past also, Rera passed the orders also that even if suppose there is an arbitration going on, Rera got every jurisdiction to pass an order on the or adjudicate all the litigation under them before them. So even if it is arbitration also, Rera got every right to adjudicate. This is my personal view, and we can take it up with a PIL or writ petition or whatever it is.
I think Supreme Court also in Pioneer Urban have clarified this.
The settled law, I think there was this finding is erroneous because in Pioneer Housing it is clarified.
Clarified.
Right. Yes.
Arbitration cannot prevail, है ना?
Not prevail. It is the choice of allotee to go before.
No, in Pioneer they have said three things: one, consumer court; second, NCLT; third is Rera.
They have said three forums, but it is the choice of allotee to go.
Yes.
Now in arbitration also, if he has the right to go, he might choose it. But if he chooses to go before Rera, it is the choice of allotee.
Correct.
Prior to
legislation,
Ramesh bhai, prior to Ramesh
which
bhai,
is very beautifully written.
Prior to filing complaint by allotee, if developer goes to arbitration, he is allowed.
Yeah. But now he is taking objection. There is a written contract, registered contract. Contract cannot be overwritten. The Rera does not have the jurisdiction to rewrite the contract. So therefore, you go to arbitration. ऐसा गौतम चटर्जी अपना अजय मेहता का judgment है.
Sir, then this suo moto all proceedings will have to go before the arbitration because the termination is pursuant to the
under section 2 and 8 of Rera arbitration, when the statutory authority confirmed authority to consider those matters, such matters cannot be taken up by the arbitration. Under arbitration, there is bar under section 79 also of Rera, as well as under section 2 and 8 of Arbitration Act. There is a bar. Then only Maharera will have exclusive jurisdiction to entertain the disputes covered under Rera Act.
Okay.
We all should have our video on so that we Aditya requested that we can take a photograph. I request every member who's there online should on its video.
सर इसमें कुछ पूछना है मेरे को और
सर एक मिनट सबको Nikki Milani, CA Uma Madhevkar, may I request all of you all to just on your video. Advocate Ram Prasad,
रमेश प्रभु
प्रभु सर, प्रभु हमारे साथ रहिए.
प्रभु के दर्शन दुर्लभ है नीलेश भाई.
Rajiv ji, just for a minute, if you can just start your video. Ramesh Prabhu sir. Sunil, we want your active participation. We want youngsters to come.
Yes, sir.
Sunil is active.
Because Ashwin bhai will be seeking some retirement after time. Satish is the most happiest to see on the video. Thank you, Umaji. Aditya, we are ready.
Yes.
Mr. Khan, Rajiv ji, Ram Prasad ji, please, can you switch on your videos?
No, madam, not able to see.
Okay, Aditya, you can take photo now.
Yes.
Done.
Yeah. Okay, friends. So we conclude today's talk, and once again, thanks to Dr. Sanjay Chaturvedi, and we expect your wholehearted participation in our future meetings and webinar, or wherever we want to make some representation. You are now part of our committee, so I need not say this. Yeah. So friends, with this, we conclude today's webinar. Thank you very much.
Thank you, sir.